Good morning and welcome to the Committees on Consumer and Worker Protection, jointly with Civil and Human Rights. At this time, we ask if you could please place phones on vibrate or silent mode. Thank you, chairs. We are ready to begin.
Good morning, everyone. My name is Natasha Williams, and I serve as chair to the Committee on Civil and Human Rights. Today, we are joined by the Committee on Consumer and Worker Protection, chaired by my colleague and co-chair of this hearing, Councilmember Julie Menon. As this year's Black History Month draws to a close today, I'm proud to be addressing an issue that greatly impacts people of color, not only in New York City, but across the country. Historically, marginalized groups in the United States have faced legal and policy barriers to accessing traditional financial institutions, including access to capital and credit for home mortgages, business loans, and other savings, credit, and investing needs. These systematic impediments constitute chronic barriers to economic autonomy and generational wealth building for marginalized individuals, with particularly severe impacts on Black Americans. Today, borrowers of color continue to face undue challenges to accessing mainstream financial institutions, including as a result of the neighborhood segregation produced by historical redlining and other discriminatory practices, some of which unfortunately continue today. As a result of these barriers, homeowners and consumers of color and minority-owned businesses are often the first and worst affected when market shocks occur, as we saw most recently during the COVID-19 pandemic. In October 2023, the New York State Attorney General's office published a report that found applicants of color in New York are denied home purchase mortgages at higher rates than white applicants, even when controlling for credit score, income, size of loan, debt-to-income ratio, and year of application. Despite federal protections against discrimination, borrowers of color are still impacted by this ongoing problem. As legislators, we have a responsibility to do what is in our power to protect New Yorkers from inequitable and predatory practices. In an effort to explore options for increasing transparency in financial borrowing and lending, the Committee on Civil and Human Rights will be hearing intro number 401 in relation to prohibiting discrimination in the issuance of credit and requiring creditors to disclose to potential borrowers how their rate is calculated. This bill is sponsored by Public Advocate Jumaane Williams. Additionally, this committee will hear intro number 69 in relations to forbidding agreements to shorten the period in which claims and complaints of unlawful discriminatory practices, harassment, or violence may be filed, and in which civil actions may be commenced, sponsored by Councilmember Ressler. And intro number 242 in relations to the creation of a truth, healing, and reconciliation process, sponsored by Councilmember Hudson. And intro number 279 in relations to creating a task force to consider the impact of slavery and passing justices for African Americans in New York City and reparations for such injustices, sponsored by Councilmember Lewis. Introduction 69, 242, and 279 were heard last session, and all testimony from the respective hearings will be incorporated into the record for today's hearings. Before we begin, I would like to thank my colleagues and everyone that has joined us today. Now I'll turn it over to my co-chair, Councilmember Julie Menon, for her opening statement.
Thank you so much, Chair Williams. It's a pleasure to co-chair this hearing with you. Welcome, everyone. I'm Julie Menon, Chair of the Committee on Consumer and Worker Protection. Access to credit is a very important vehicle for individuals to access both economic opportunity and to build wealth. By taking on a mortgage to purchase a home, families build equity in an asset and maintain stable housing. By taking out a business loan, New Yorkers without deep pockets or connections can realize their dream of starting a business. And by securing an auto loan to buy a car, workers can expand the jobs that are available to them. While loans can be engines of opportunity, deceptive and unfair practices can turn them into debt traps for low-income New Yorkers. Predatory lenders target vulnerable individuals with loans that have high interest rates and hidden fees, making it difficult for borrowers to pay them back, and debt collectors may harass borrowers or make false claims to coerce them into making payments. In response to these dynamics, the City Council has enacted legislation to ensure equal access to credit and protect consumers from unfair practices in lending and debt collection. The New York City Human Rights Law prohibits discrimination in mortgages and loans, and the Consumer Protection Law forbids all deceptive or unconscionable trade practices around both lending and debt collection. However, marginalized groups in New York City still face discriminatory practices when trying to access credit. As Councilmember Williams mentioned, an analysis published by the New York State Attorney General's office in October found that applicants of color are denied mortgages at higher rates than white applicants, even when controlling for factors such as credit score, income, and size of the loan. The report also found that people of color who are approved for home mortgage loans are given worse terms than their white counterparts, with higher interest costs and fees. And there remain bad actors that prey on financially vulnerable consumers to get them into loans. Just last month, DCWP announced an agreement that will deliver $1.5 million in relief to New Yorkers harmed by 6 used car dealerships' deceptive sales practices, including forcing consumers into financing deals and providing false information to financial organizations to secure loans. And back in 2014, when I served as commissioner of DCWP, we heard reports of New Yorkers receiving predatory auto loans from used car dealerships. People would be pushed into new products that would drive up the cost of the loan. As a result, as commissioner, I oversaw a program that would have reputable banks and credit unions provide direct loans to consumers, particularly low-income consumers. There were several requirements to this, including interest rates that were lower than the usury rate of 16% and no required add-ons. The agency played a key role in ensuring consumers had a fair and safe loan to access. After decades of exclusion from financial institutions, it's critical that people of color, immigrants, and low-income New Yorkers are able to access credit, but not under conditions that jeopardize the benefits of access. I look forward to hearing from the administration regarding their efforts to educate consumers about their rights and enforce the city's human rights and consumer protection law around lending and debt collection. I want to thank committee staff Sarah Swain, Natalie Meltzer for their work in putting this hearing together, as well as my chief of staff, Jonathan Shutt, and my legislative director, Brandon Jordan, for their assistance. And now I'm going to turn it over to the public advocate, Jumaane Williams, for his statement. Thank you.
Thank you so much. As mentioned, my name is Jumaane Williams, public advocate for the City of New York. I want to thank our chairs, Menon and Williams, and members of the committees on Consumer and Worker Protection and Civil and Human Rights for holding this hearing. Today I'll be speaking on Introduction 0401, of which I am the prime sponsor. The bill would prohibit discrimination based on an individual's membership in a protected class in the issuance of credit and would require creditors to disclose to potential borrowers how their rate was calculated. More specifically, the bill would deem it an unlawful discriminatory practice for any creditor or any officer, agent, or employee to discriminate in the granting, withholding, extending, or renewing of any form of credit on the basis of an applicant's race, creed, religion, national origin, sexual orientation, age, gender, and disability, among other classifications. I first introduced this bill during my tenure as a council member in 2016. The bill's original introduction in 2016 was inspired by a $24 million settlement alleging that Honda creditors engaged in a pattern or practice of discrimination against African American, Hispanic, and Asian Pacific Islanders borrowers in auto lending. It has been nearly 10 years since the bill was introduced, and the need for it still remains. In 2023, Citigroup settled for $26 million for claims that its employees denied Armenian Americans fair access to Citigroup credit cards. Mortgage lenders such as Wells Fargo and Navy Federal Credit Union also face heightened scrutiny and lawsuits on their lending practices and hiring disparities, notably between Black and Latino homeowners against white homeowners. And I met with Wells Fargo myself shortly before the news broke, and they vehemently tried to suggest that this was not the case, while it really appears that it is. Currently, there are federal laws such as the Truth in Lending Act and the Equal Credit Opportunity Act that provide safeguards for consumers in their dealings with lenders and creditors. The city should enact similar policies at the local level that fortify existing consumer protection laws. Intro 0401 could help hundreds of thousands of people applying for mortgages, small business loans, and other types of credit. Having in place a law that mandates transparency in how a person's interest rate is calculated will also protect groups of people in the city that face historical discrimination and unfair treatment when it comes to banking, homeownership, and accessing financial opportunities. I urge my colleagues to sign on to this bill and hope for its subsequent passage. I would also like the clerk to please sign me on to Intro 69, 242, 279, which sound like great bills as well. Thank you so much.
Great. Thank you, Public Advocate. I also want to mention we've been joined by Councilmember Ressler. Yes, and I'm going to turn over to him to make a statement on his
Great.
bill. Thank you.
Thank you so much, Chair Menon, and I want to express special gratitude to Chair Williams for the opportunity for a hearing on this bill today and for her tremendous partnership as a colleague here in the Council. And I want to thank the administration for more warmly testifying about Intro 69 than the last time we had an opportunity to engage on it. So thank you for crisper and clearer testimony today on this topic. Just briefly, because I know it's not the central thrust of our hearing, but just to explain Intro 69 on the record, under the city human rights law, our landmark human rights law that I know that our colleagues at the Human Rights Commission and many New Yorkers are immensely proud of, employees have 3 years to file claims for discrimination, harassment, violence in the workplace. And too many employees have been unknowingly signing away their rights and their protections in contracts that their employers are giving to them. And this is not a rare occurrence. Unfortunately, some of the largest employers in the state of New York are perpetuating this practice. And it is undermining the protections that New Yorkers are guaranteed. Employers like Northwell Health, the largest employer in the state of New York, Raymore and Flanigan, FedEx, other big corporate entities are hurting New Yorkers. It is an absolute tragedy when harassment and discrimination occurs in the workplace. But the idea that New Yorkers would unknowingly sign away their own rights to be able to hold their employer accountable when that horrible action happens is unacceptable. And the truth is, many of these employers only give their employees a 6-month window after the incident occurs to pursue legal action. And for those who have been victims of harassment or discrimination, it takes time to process what's occurred. It takes time to find a lawyer. It takes time to file legal action. 6 months is essentially a way for employers to prevent their employees from pursuing legal action altogether. That's what that time frame means. We created the law where 3 years is the appropriate time frame for employees to be able to pursue legal action for good reason. And we should be protecting that law. And I'm really appreciative of the opportunity for a hearing on Intro 69 today, appreciative of the Human Rights Commission's warm testimony. If there is feedback on this law, we would request that you provide it as quickly as possible in writing because we are eager to move this bill forward. So thank you very much, and really just special thanks to Chair Williams for being an exceptional partner and to Speaker Adams and her team for their willingness to support this as well. Thank you very much.
Great, thank you. I also want to mention we've been recognized by Councilmember Joseph. So we'll now turn it over to Committee Counsel. Thank you.
Thank you, Chair Menon, Chair Williams. Good morning. I'm Jessica Boulay, Counsel to the Committee on Civil and Human Rights. Before we begin testimony, I want to remind everyone who may be joining on Zoom, you will be on mute until you are called on to testify. I will be calling on public witnesses to testify after the conclusion of the administration's testimony and council member questions. So please listen carefully for your name to be called. Council members, you will be called on for questions after the panel has completed their testimony. I will now call representatives of the administration to testify. We will be hearing testimony from the Commission on Human Rights and the Department of Consumer and Worker Protection. At this time, I will administer the affirmation. Our panelists today are Joanne Kamouf-Ward, Deputy Commissioner of Policy and External Affairs, and Hilary Scrivani, Senior Policy Counsel, both at the Commission on Human Rights. And from the Department of Consumer and Worker Protection, Carlos Ortiz, Assistant Commissioner for External Affairs, and Andrew Schwenk, Associate General Counsel. Panelists, please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and to respond honestly to council member questions?
I do.
I do.
I do.
All right. Thank you. At this time, I'd like to invite Deputy Commissioner Kamouf-Ward to begin testimony.
First, great job with the name pronunciation. It's a challenge, so thank you. Good morning, Chair Williams, Chair Menon, Public Advocate Williams, Councilwoman Joseph, Councilman Ressler, committee staff, and everyone who's put together this hearing this morning. I'm Joanne Kama-Ford. I'm Deputy Commissioner of Policy and External Affairs at the Commission on Human Rights, joined by Hillary, as Jessica mentioned. We're very thankful and honored to be here for this important topic. These are large-scale challenges which take local government, federal government, state government, and many stakeholders to address. And we're excited to highlight some of the Commission's work that addresses discrimination and advances equity, and to be here with DCWP as well. So I think as many people on the council side know, the human rights law prohibits discrimination on the basis of more than 25 protected categories in housing, employment, and public accommodations. And in the past year, the human rights law was expanded to address critical barriers to equity for New Yorkers. I'm going to give a brief overview of our dual mandate and the human rights law's provisions, specifically that operate to address historical and ongoing disparities, with a focus on employment and housing, and there's more detail on our structure in my written testimony. First, the Commission engages in outreach and education to raise awareness of the human rights law's protections and to strengthen relationships with and between communities through events, workshops, and trainings. This is done primarily through our Community Relations Bureau. Engaging with and hearing from New Yorkers are critical components of preventing discrimination and translating legal protections into tangible change for community members. To this end, we've engaged in participatory research projects to inform our work over the past decade. Second, individuals who believe they have experienced discrimination or harassment in violation of the human rights law can report discrimination directly to the Commission's Law Enforcement Bureau, or they can choose to file a complaint in state or federal court. If individuals come to the Commission, the Law Enforcement Bureau launches investigations, can initiate complaints, can enter settlements, and can take cases to administrative trial to address discrimination. If appropriate, individuals can also choose alternate forums to seek redress at the state or federal level. The highest number of claims that come before the Law Enforcement Bureau relate to the protected categories of disability and gender. In light of today's topic, I want to spotlight portions of the human rights law and the Commission's work that address barriers to equity. So starting with the workplace, which is where we see the highest number of claims in law enforcement, the human rights law has a number of provisions that enhance equitable hiring and employment for New Yorkers. The human rights law was amended in 2022 to require that employers post a good faith wage range in job ads. This provision complements the prohibition on employer inquiries into applicants' salary history during the hiring process. Additionally, the human rights law prohibits employers from asking about a job applicant's credit history, which is relevant, I think, to today's hearing topic, and prohibits employers from asking questions regarding an applicant's involvement with the criminal legal system until after an employer makes a conditional offer. Together, these provisions address practices that have long contributed to wage disparities and hindered access to opportunities and economic mobility for women and people of color. In the arena of housing discrimination, the Commission has longstanding expertise. The law has some of the most expansive protections in the nation, and housing is one of the most active areas of enforcement, specifically preventing and addressing voucher discrimination, which I know is a priority for this Council. The Commission is also currently preparing outreach efforts to inform all New Yorkers that New York City will prohibit discrimination on the basis of criminal history in housing beginning in 2025. That's a result of the Fair Chance housing legislation adopted in December of last year. The human rights law also prohibits discrimination in all aspects of the sale and rental of housing. Finally, the human rights law prohibits public accommodations from discriminating against individuals on the basis of a protected category. I will now turn to the proposed legislation. As mentioned already, Intro 401 seeks to address discriminatory lending by amending the city human rights law to prohibit differential rates for loans and credit issued in New York City on the basis of several protected categories. 401 also requires the Commission to undertake a number of tests and investigations regarding discriminatory lending practice. The administration supports the goal of ensuring equitable access to credit and the objective of cultivating intergenerational wealth for all New Yorkers, regardless of identity. The administration is currently reviewing the complex arena of credit, which is largely regulated by federal and state laws, and where an array of government entities have oversight authority to identify and address discrimination and other aspects of credit, which have also been mentioned already this morning. This hearing is a welcome opportunity for the administration and the commission to hear from stakeholders on this important topic. Turning to Intros 242 and 279, the administration's positions on these bills, establishing a truth and reconciliation process and a reparations task force, remain as expressed in the testimony by the Mayor's Office of Equity and Racial Justice at the Juneteenth bill package hearing this past September. In summary, the administration supports a truth, healing, and reconciliation process and a task force to study reparations, but as detailed by Commissioner Sherman, would like to see greater alignment between the two efforts, an extension of the timeline for both reparations and truth and healing, and wants to ensure adequate resources and expertise are embedded into these efforts because they are significant and can be transformative for New York City. Intro 69 would render unenforceable and void any and all agreements that shorten the statute of limitations for filing a case with the Commission or filing a complaint in court, including agreements that are already in place. The administration supports the public policy aim of preventing coercive contract terms that contravene the rights of New Yorkers to pursue claims of discrimination. The Law Department continues to review how the current draft comports with constitutional contract law principles and New York case law. In doing so, the administration is specifically analyzing legal considerations regarding the bill's retroactive application to contracts that are already in place. The administration looks forward to working with Council to ensure New Yorkers maintain the ability to vindicate their rights. And in closing, the Commission is committed to preventing and combating discrimination in New York City. We appreciate the Council's attention and commitment to addressing these issues, and we welcome your questions today and your partnership moving forward.
Good morning, Chair Menon, Chair Williams, Public Advocate Williams, and members of the Committees on Consumer and Worker Protection and Civil and Human Rights. I am Carlos Ortiz, Assistant Commissioner for External Affairs at the Department of Consumer and Worker Protection, and I am joined by our Associate General Counsel, Andrew Schwenk. Our agency's mission is to protect and enhance the daily economic lives of New Yorkers to create thriving communities. While we do not regulate bank and lending services, our work does focus on improving New Yorkers' financial health and our enforcement of key consumer protections. And since the start of the administration, we have helped deliver $319 million to the pockets of New Yorkers across all our areas of work. DCWP is committed to protecting consumers from deceptive or predatory trade practices in the marketplace and ensuring that consumers have relief if their rights have been violated. We accomplish this through robust enforcement of our licensing laws and of the city's hallmark consumer protection law. For example, we license approximately 470 used car dealerships across the 5 boroughs and regulate specific requirements dealers must adhere to regarding our consumer protection standards. These include price display requirements, various disclosure requirements, including a financing disclosure, and a prohibition on false advertising. Moreover, under the Consumer Protection Law, all businesses are prohibited from engaging in deceptive or unfair trade practices. Under Mayor Eric Adams' administration, we have announced major victories on behalf of consumers through proactive investigations into used car dealerships, in total securing more than $7 million in restitution and civil penalties in this specific area of work. A recent highlight of our work into used car dealerships was just announced this past January, concerning an entity known as 26 Motors. Our agreement secured $1.5 million in restitution for consumers, required the closure of 5 dealerships, and barred 5 individuals from owning a used car dealership for the next 5 years. We've also brought significant cases against for-profit colleges under the Consumer Protection Law, such as Berkeley and ASA College, for running misleading and deceptive advertising. In just those 2 cases alone, we secured close to $500,000 in civil penalties, as well as $20 million in debt relief for New Yorkers. Each of these cases drives home the message to New Yorkers that this administration will continue to protect and support working people in our city. We also strive to ensure that New Yorkers are educated on their rights and protections. And since the start of the administration, we have held more than 1,400 outreach events, reaching over 105,000 attendees to educate New Yorkers about DCWP. DCWP also offers innovative programs and services to support New Yorkers in improving their financial health. One of our key programs is our network of financial empowerment centers. Residents across all 5 boroughs can visit for free one of more than 37 financial empowerment centers to receive confidential, one-on-one professional financial counseling. Our trained financial counselors help clients navigate their finances, create a budget, open safe and affordable bank accounts, and so much more. Our financial coaching and counseling places an emphasis on financial education to help clients reach both short-term and long-term financial goals. Clients that come to our centers looking for assistance with loans are provided with an in-depth understanding of their rates, terms, and possible risks involved. And we also offer additional options for clients to find safe and affordable financial products, including bank accounts. Since the inception of the Financial Empowerment Centers, we have served nearly 77,000 New Yorkers, helping them reduce their debt by $106 million and increase their savings by $12 million in total. We are incredibly proud of our financial empowerment programs overall and the successes that New Yorkers have achieved. As I mentioned earlier, DCWP is committed to protecting and enhancing the economic lives of New Yorkers, and we look forward to working with this council to find new and innovative ways to continue doing so. Thank you for the opportunity to speak today with you, and I look forward to your questions. Thank you.
Thank you. I just want to acknowledge that we've been joined by Councilmember Osei, Riley, and Abreu. Thank you so much for your testimony. I have a few questions for the commission. So what possible hurdles, if any, does CCHR anticipate in the implementation and enforcement of Intro 401?
Thank you. As always, happy to talk about our work and to be with this committee. The administration, as I noted, supports the intent of the bill to prohibit discrimination in the issuance of credit and to require creditors to disclose to potential borrowers how their rate is calculated. I think we're very interested to hear from stakeholders who do this work every day, their perspective on the bill. But I will mention just a few of the things that have come up as we do our sort of initial review of Intro 401. As was already noted, there is a fair amount of state and federal regulation, both on the anti-discrimination side and on the transparency side. And so part of the work the administration is doing is identifying how law at the local level would fit in with existing protections and to identify if there's any conflict with those existing laws. I think one from CCHR's perspective, the work that we do often, as I noted in my testimony, involves individuals coming to us to file complaints. We're a file as of right agency, which means any New Yorker has the ability to come to us to file a claim of discrimination, and we are obligated and pleased to be able to serve those New Yorkers and to identify if they have a viable claim. We also do testing in housing, employment, and public accommodations. I think one of the concerns CCHR has with the bill is the testing requirements. We understand from just preliminary conversations that testing in this space is extremely complicated. There are some hurdles that are much different than the other kinds of testing that we do. So, for example, to identify if someone is giving a differential loan rate on the basis of a protected category, you would have to have two testers with almost identical financial profiles apply for a loan, find out what their credit score is, and then be able to analyze those credit scores to identify if the protected category was the basis for differentiation. That's both a long process, but would require testers to be able to have a financial profile and identity, which is not something currently that we are able to do. A lot of our testing in apartment spaces or in employment can be showing up to a housing provider. Someone we'll have applicants with very similar profiles, but for a protected category. So a woman goes to ask for an apartment and possibly has her child with her, and she's told, "I'm sorry, we don't have an apartment." A single male might go ask the same housing provider 3 hours later for an apartment. They say, "Yes, we have one we can show you right now." That's discrimination potentially on the basis of gender, potentially on the basis of race, and also potentially on the basis of presence of children. So that's a much different kind of test than I think what's contemplated in this bill.
Thank you. Do you have any thoughts with respect to the outreach and education required by the bill?
Sure. So, as you're probably sick of me saying, we really see our prevention and education work as a critical part of addressing discrimination. As has been already noted, there are some lending protections in our law. Those are part of the outreach and education that we do every day in the housing space. Our Community Relations Bureau, for the past several years, the time that I have been at the Commission, have increased their outreach and education efforts every year, reaching more than 100,000 New Yorkers in fiscal year 23. So we are excited about education in this space. I think that the challenge is, again, goes back to some of the immense number of laws and regulations and the specifics of financial expertise that apply in this field, and identifying who are the right messengers for some of that information. But it's already part of the work that we do, and we are excited to think about ways to expand that work with council, with sibling agencies, and with other stakeholders.
Okay. Does CCHR receive any inquiries in relation to discriminatory lending practices? And if so, could you share how many and what these type of inquiries consist of? I'm not talking to myself. Yes, so we do have these protections. They're part of our trainings. I would say this is a very small number of the cases that we receive in terms of inquiries and complaints. It's really a handful over the past 5 years. I think the most we've had in a year is 8, which is a small number. I think there's lots of reasons for that. Part of the reason that we see that is, as I mentioned in my testimony, New Yorkers have a lot of choices when it comes to addressing discrimination. A lot of the cases around financial products are handled in courts where you can pull in federal and state law. I think another challenge in this space that makes it very hard to regulate is that often individuals who have been who have experienced discrimination in financial products do not realize that until the time when they bring their loan documents that they may have signed. I don't know how many people here have a mortgage. I have one. I signed millions of pieces of paper. I don't know what they all say. It's really complicated, and you might not find out about the coercive or discriminatory terms until years after you've been paying off a loan. So I think those make it a challenge for an agency like ours, which are often dealing with individual acts of discrimination in a particular time frame. Okay, would CCHR and CWP consider coordinating on financial and lending education and outreach?
I can take that one. So I think for ourselves, education is a cornerstone of the work of the agency, ensuring folks understand what their rights and protections are. That applies to consumer protection, financial empowerment, even worker protection too. So we would always be happy to partner with our sibling agencies in that sense to get the word out. And we do partner currently on events as well. So it's really, I think, part of the efforts of this administration to ensure we're coordinated at all times.
Yeah, and I'll just add to that, in the education and outreach, the public-facing work we do in concert already, and we think that's effective since there's a wealth of information that both of our agencies hold. We also refer cases to each other or to other agencies or organizations when that's appropriate. So there's information sharing also outside of the event space.
And I know that there are minimal cases that come to CCHR in reference to discriminatory lending practices, but do you see other types of complaints that might feed into or result from discriminatory lending practices? So maybe the complaint wasn't explicitly that, but it might be a part of it.
So maybe not as expressly as you're identifying, but I think, again, when we talk about employment cases and looking at credit history, the fact that credit history is asked for in many spaces. If you have bad credit or have been the recipient of unfair terms and you're still paying that off, that has knock-on effects that can occur in employment. That's why the prohibition on asking those questions, which are 100% irrelevant to your ability to be a good employee, is a really important part of our work. I would also say that the work we do in the source of income space and vouchers is also a knock-on effect of some of the challenges in generating intergenerational wealth and in limits to economic opportunity, because we know that in the source of income space, most of the claims that come to us, and I think it's fair to say most of the voucher holders in New York City, are people of color. And so this, I think, is all related in a way that is both complicated, but something that we can work together, I think, to address.
Yeah, I put in some bills on credit history, discriminatory action. So let's see, from first in time. We have a nice little process here in the council. So the next question I have has to do with artificial intelligence impacting discrimination and lending practices. And if I could just reframe that a bit, I'm just wondering your knowledge of any trends you're seeing. I know you mentioned credit history trend, but if there are any other trends you see, and then adding into the advent of artificial intelligence, and if you think that would also have disparate impacts on discrimination and lending practices.
So this is really from my personal thinking. I think it would be very difficult to say that AI isn't going to allow for discrimination to be harder to identify, right? I mean, I think there's evidence of that. I think that is definitely going to impact lending. It's already a complex area to regulate, and I think AI makes it so the decision making is more diffuse, amorphous, and it's harder to identify in the work that we do the respondent, right? Who was the decision maker? So I think that will be a major challenge, and that's why the transparency piece is so important. But in terms of our work, I think we haven't seen these intersections, but we're definitely thinking about them and watching what's happening both in the employment space and the housing space to both see what federal regulators are doing and to understand how it might come to our agency.
Thank you. I'll turn it over to my co-chair, Julie Menon, for questions.
Thank you so much, Chair. So a number of questions for DCWP. The Debt Collection Guide for Consumers, which was last revised in September 2023, states that debt collection has been the #1 complaint category for the agency in recent years. Can you tell our committees how many debt collection-related complaints you've received annually over the last 5 years?
I'm sorry, Chairman, I don't have the particular number on complaints of debt collection agencies. I generally, across all of our laws and rules and categories, we receive about 26,000 complaints. I'm happy to pull the number for you.
26,000 in total over
the calendar year of 2023. Yes.
So in 2014, when I served as commissioner of DCWP, the agency mediated 382 consumer complaints against debt collection and debt settlement companies. Over the last 10 years, that steadily declined. The agency mediated just 41 consumer complaints against debt collection and debt settlement companies in 2023. So I'm incredibly concerned about that. If that's the agency's #1 category of complaint, why are the numbers so low?
I'm not. So I think I would love to get perhaps a range of which our priority complaint categories are. I think for us, mediating complaints is part and parcel of the essential work we have to do. I know that process itself is very. It involves many communications with the consumers. We definitely want to make sure that they're being helped throughout these processes. So I think I would love to get the specific data for you, and we could talk through more of the complaints.
My concern is you have in your debt collection guide that it is the #1 complaint category. So that's out there. That's the #1 complaint category. So why would the number be dropping from where it was a decade ago to where it is today?
I totally hear your concern on Chair Menon on this issue, and I think I just want to be able to pull the information for you on this. I'm not aware if it dropping in recent years, perhaps compared to 2014, but I haven't seen those numbers either. So I'm happy to, when I have the information in front of me, I can bring it to
I
you.
do just want to say this is very disappointing. I mean, this is a hearing on this topic. You know, if it's the number one complaint of the agency, you should have that information available. And I'm not pulling out information from a hat. It literally, we have the information that the agency mediated just 41 consumer complaints against debt collection and debt settlement companies in 2023. That number has gone down precipitously.
I'm sorry, Councilman, we don't have the debt collector information for you. My understanding was that the request was for us to talk about our secondhand dealer work, so I have some of that information. But again, I'm sorry I don't have the debt collector information. I will get that for
Okay,
you.
if you can get that to our committees. On auto loans, so I spoke in my opening statement about, you know, an initiative that we launched a decade ago on auto loans. Can you give the committees an update on what is happening in terms of predatory loans? What is it, and you mentioned some of it in your testimony. What is the agency doing to deal with that issue?
Yes, of course. I think some of the work and that we've seen through our used car dealership investigations and inspections and in response to complaints, I think it's some of the core work that we do at the agency. As I mentioned, under the Adams administration, we've been able to secure more than $7 million in restitution and civil penalties around used car dealerships. With respect to the initiative that you mentioned from 2014, my understanding from that time is that we put out an RFEI and an RFP for that program initiative. However, there was a low uptake on that response that made the program unviable at the time. That said, I think we took the lessons of that initiative and the goals of it in terms of providing more information to consumers and used that to implement new legislation that came out in 2016 and 2017, which has strengthened our hands in terms of regulating used car dealerships, particularly with respect to disclosure requirements, but also robust record-keeping requirements. And that has borne fruit now, from 2014 to now, of our secondhand car dealer work.
Okay. For-profit colleges, you mentioned Berkeley. We began that investigation when I was at the agency. You mentioned relief for Berkeley. What about the other for-profit colleges that we subpoenaed?
Well, in the particular case of Berkeley, NASA College, I think those were the situations where we saw and were able to collect evidence and observations that were able to bring a case to the Office of Administrative Trials and Hearings. I'm not familiar with the other cases or the other for-profit colleges that you're saying were committing violations.
The other ones were Mandel, New York Career Institute, and TCI. We had an investigation into those as well as to Berkeley.
I think ultimately, in looking into those cases and processing complaints, we were not able to proceed with a summons, and we instead focused on the cases, in the case of Berkeley College, where we had observable violations that we could bring to oath.
Okay, so just so I understand, so for all of the consumers who complained about these other 3 for-profit colleges, what is the relief for those consumers, those students who were, because we had, you know, tremendous complaints at that time, so if you don't have that information now, if you can please get to my committee that information for those other 3 for-profit colleges.
Yeah, I would happy to get that to you. I'll check in on the mediation work that we performed during those cases as well to assist the consumers.
Okay, in terms of OFE's 37 financial empowerment centers, can you speak, you said something in your testimony about it, can you speak more about what is happening in terms of preventing deceptive or discriminatory practices against whether it's, you know, debt collectors, predatory lending? I'm very interested in what Chair Williams mentioned about the 2 agencies working more collaboratively together. I mean, does CCHR have materials at the OFE centers around the city?
So with respect to our financial empowerment centers, we ensure that our counselors are trained either through our consumer services team or our consumer protection team to identify when issues come up, such as potential violations of their consumer rights. We also hold quarterly trainings for our counselors where we invite sister agencies to come in and also describe particular issues that they should be looking out for in order to serve their clients. I think for us, it is a particular, the Financial Empowerment Center location and that interaction between the counselor and the client is a particular moment where we can really jump in to serve a New Yorker. Moreover, we do have a legal services contract with NILAG That contract, we're able to refer individual cases out to NILAG. These could refer to potential issues around auto lending, for-profit colleges. I think we've received, over the past year, we were able to refer out 300 cases to NILAG in that particular situation. Again, I think for myself and CCHR, coordination is essential. We do deliver to our financial empowerment centers as well as our free tax prep locations, of which there are over 140, literature from our sister agencies as well as our own literature.
Okay. Before I turn it over to the public advocate for questions, first want to recognize we've been joined on Zoom by Councilmember Salamanca. So one other, and we've been joined by Majority Leader Farias. We've been joined by Councilmember Marte. Thank you. One last question I have, and this is for CCHR. You mentioned in your testimony that the highest number of claims that come before the Law Enforcement Bureau relate to the protected categories of disability and gender. How many gender complaints were there last year?
So I don't have the number, but we will pull it during this hearing, and we will tell you. Yeah.
I'm just not trying to be difficult here. I'm just saying we're having this oversight hearing, and it's frustrating when agencies don't have, like, this is in your testimony. This is a basic question. You're saying it's one of your top complaints. It's sort of the same issue I'm having with DCWP. When you testify that something is a top complaint, you should have that information readily available for the committees. That is just like a basic rudimentary courtesy that we would ask agencies when they're coming before committees. So I'm happy to turn it over to the public advocate.
Thank you so much, Madam Chair. This is my question for CCHR. Just following up on one of the questions Chair Williams asked about difficulties of implementation enforcement. So I heard kind of two things that might be difficult, where it fits in. Also, what I'm calling kind of the ease of doing it. To actually follow up on any complaints. And I was at another possible, which is the funding to actually get it done. So I just want to know, of those three, which seem to be the most concerning?
So I think for this particular area, I will say resources are a challenge. That means expertise. And financial expertise, which is not something that is currently like a hiring requirement when we're thinking about discrimination complaints. So I think we would have to look into how do we have the person resources to be able to do this work accurately. I think that the testing piece is also significant because I think it's real legal hurdles. Some of the other things are more practical. I think being able to do the testing in this way would be very challenging.
Okay, 'cause I always find that having a local right of action makes things a little easier for people who may have the issue, which is why we try to get some local laws, even if they're preceding ones in the federal and state.
Yeah, and I think I'll just say to that, I think part of the reason people, and I think I flagged this in my prior answers, but part of the reason I think people go to court is because they can use all the laws, right? Like when you come to the commission, we can look at a city human rights law violation. If you go to state or federal court, you can use the Fair Housing Act. And so I think there's...
Yes, but you also have to have money for attorneys to be able to do all of those things. A lot of folks have trouble navigating those parts of it if they don't have the resources to do it.
Yeah, and I think that's part of the reason, again, I'm not an expert in HUD or in federal agencies. You know, HUD has funded nonprofits. I think there's 30 to 50 across New York City to do some of this work exactly for the reason that you're talking about. But yes, I hear you.
And I mean, this is probably for another hearing. I do think the agency needs definitely some more funding, and I'm concerned about the type of testing that's not happening, even on housing. That's a whole nother conversation. I think there's a lot on the table, a lot of discrimination happening right now that the agency is not able to catch it for various reasons. But with the ease of doing, I just want to know, the part of the law will make it so that people have to give the reason that they're being denied, and so that part of the law that has to give the criteria, would that make it a little easier to try to get what we need accomplished, even with the testing, having some of that additional information?
I think my preliminary response is that transparency in how these decisions are made are going to aid in addressing the discrimination, but I'd have to look more closely at what is already required and where things are not being conveyed to individuals who are looking for credit or mortgages.
Sorry, say that last part again.
So I think I would personally, and CCHR would look, and the law department would need to look more into what is already required to be provided under state law and how this might differentiate. Because I think, as we've said, there are laws in place. I think the laws get so far, and culture shift and changing how business is done is a much different kind of animal.
Okay, thank you very much. And for DCWP, just I guess it's more of a comment, but because I'm happy that the chairman is focused on used cars as well. I was focused a lot when I was a council member. I just want to say I think I still see a lot of stuff happening there that's not being captured, and I don't know if people have the ability to always, when they're searching for a car, these are folks that always don't have the time. So I don't know how much you're going out just on your own to do some testing. I had a big issue myself with Major World. I don't know if there's still an issue. I hear a lot of their ads still on, but they were doing a lot of bait and switch back, and this is way back. And so I don't know how much you're going out, or how much is just waiting. I guess it's a question. How much is it waiting for people to come with complaints, and how much is you proactively going out there?
Well, let me just jump in quickly on the Major World situation. I know that was a big case for us that we just finalized this past year, actually, and secured $3.5 million in penalties from Major World for the deceptive practice they were engaging, as well as previous years where we were able to also secure restitution for consumers that were impacted. So I thank you for elevating that, and certainly if there's more violations being committed by that business or other business entities, we would certainly want to know about it.
So Major World has been fined for the work that they've been doing?
That's correct. We initially began that investigation process years ago. Of course, through the course of appeals that they were engaged in, ultimately the city was able to win out on that case, and we got $3.5 million in civil penalties from them on it.
I'm hoping we can check to make sure that they've changed practices.
Yes, certainly. I think when our practices are when we find businesses that have violated the law, we do work to ensure that we're following up on them to make sure they're staying in compliance. I think to your question earlier, we do proactively inspect locations across the city, used car dealerships, I should say, as well as respond to complaints. And then I think the third prong of that as well is proactive investigation work from our attorneys at the agency that also looks into the record-keeping requirements of these used car dealerships to ensure that they are complying with all aspects of the licensing and the consumer protection law.
Thank you. Thank you, Madam Chair. Madam Chair.
Thank you so much. And now Councilmember Ressler has some questions.
Thank you so much, Chair Menon and Chair Williams. Just wanted to follow up on Intro 69. Appreciate the administration's support of our public policy aim here. So thank you for that. I did just want to go a little bit back and forth on the concern relating to retroactivity, if it appears that's your primary concern with the legislation. Is that right?
Yes, that's correct.
I love simple answers. Yes and no answers bring me joy. We so rarely get it at our hearings. But I digress. So I feel very strongly that this bill should absolutely apply retroactively. The legislation's aim, the current policies of certain large employers are against the public policy of the City of New York. Are you familiar with the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, the federal legislation, which determined that pre-existing agreements to such claims were unenforceable?
Thank you for your question, Council Member. As far as federal legislation, I'm aware of it, but we don't work with federal law. So beyond that, but I am aware. Yeah.
I would also ask: have you followed the New Jersey State Supreme Court's ruling that contracts against public policy are able to be, that contracts that are against public policy can be, that we can pass legislation to enforce them we can pass legislation to enforce retroactively the contracts that have been signed that are against public policy, that undermine those contracts?
Thank you for your question. In speaking about two things, you mentioned court case and legislation. I'm not aware of any legislation, or the administration. I'm not aware of any legislation out of New Jersey thinking about a court case. Those tend to be based on specific set of facts or specific contracts. I think with this bill, and the reason that the administration is, analyzing how it works out with contract law, is that it's very broad in scope. It's applying to all sorts of contracts that have these provisions, even ones where they had been negotiated by the parties.
I raised the New Jersey example just to cite that the New Jersey Supreme Court specifically found that contracts that undermined their state's human rights law, that diminished and undermined the rights and protections of workers in their state, were against public policy, and that as they applied, the existing contracts that were in place were not enforceable. And we believe that any contract that has been signed by an employee that undermines the protections that are guaranteed in the city's human rights law should be not only unenforceable and void, but and that we want to make sure that that is retroactively enforced. And we recognize that as a broad scope and mandate, but the human rights law has a broad scope and mandate, as the Deputy Commissioner testified, and as we all know well. And I think it would be a real harm to workers in the city of New York if we did not do everything in our power to protect their rights to hold employers accountable who have discriminated against them, who have harassed them. And if we fail to impose retroactive applicability, then we have failed those employees.
Thank you, Councilmember, for sharing that. The Commission is committed to making sure that employees who have experienced discrimination can seek redress for that, and we do support the public policy aims, and we are eager to discuss further this bill and work with you there.
Do you think if you're concerned about us taking such a broad approach on retroactivity, is there a narrower approach that you would recommend?
Yeah, I think I would just say that we would need to consult with the law department and see proposed language to be able to opine on that. But I think we're very interested in moving some of these aims forward and want to stay in dialogue with you about that and bring the law department into the conversation as well.
Okay. No further questions. Thank you so much.
Okay, thank you, Councilmember Ressler. So a few more questions. For CCHR, a question in terms of the Commission's dual mandate, and I'm just going directly from your testimony, the human rights laws, anti-discrimination provisions that operate to address disparities with a focus on employment and housing. Can you talk about how many cases you're receiving, how many complaints in that area, and how many cases you're able to close?
Yeah, so first on the case and the inquiry numbers that you asked about before, I want to bring those into the testimony. So we had, and this is from last year, fiscal year 23, the number of disability inquiries we had was about 600, with 200 of those in the employment space. A lot of the disability work is in housing, reasonable accommodations, and accessibility. There were about 200 in the gender space, with a vast majority of those also in employment, and that can range from pregnancy, lactation accommodations to differential treatment, hostile work environment, sexual harassment. So for housing claims, I am just going to need to pull up our annual report to be able to have the numbers in front of me. But I can say in general we get about 12,000 inquiries a year to our law enforcement bureau, and we file in the arena of like 300 to 500 complaints coming out of that. Again, a lot of things that come to us are sometimes non-jurisdictional. Sometimes people don't want to move forward with the claim. Sometimes it's best referred to someone else. But that's kind of the universe of, and those numbers have been growing over time. In terms of cases closed, I think there is no average. I could give you an average number. I don't think it's very helpful because the scope of the cases is so different. So someone might come to us and they are seeking a ramp in their housing, and someone might come to us and they're seeking a pregnancy accommodation. One of those can be resolved probably in a day. One of those can take 3 years. So that there's a wide array of factors that go into each case. I'm about to drop something. But the other piece I would say is that in addition to filing complaints, something that our law enforcement bureau does in the case of disability often, but also in source of income, is we have a process called pre-complaint interventions. So if something comes to us and it's a matter that if we can solve it in 30 days or 2 weeks, it's going to make a tangible difference to someone, we route that through a fast-track process so that they don't have to wait to file a complaint, meet with an attorney. So we have interventionists that take some of the cases. This is especially true in reasonable accommodation and SOI when we know someone is ghosted, an apartment is going to be lost soon. So we prioritize those cases. And I say we, it's our law enforcement bureau. I'm not the one doing that work, but yeah.
And how many investigators do you have on staff right now?
So that's a good question. Our law enforcement bureau currently has 54 staff. Our attorneys serve through the life of a case. So you do the intake, you do the investigation, and you stay with the person who has filed that complaint. So our attorneys are our investigators. So we have, I want to say, in the realm of 10 to 15 attorneys. I think that's correct currently, but we have interventionists that are also part of the law enforcement team and administrative staff who do some of the intakes and the earlier process of complaints.
I know that Chair Williams and I share the concern about staffing at your agency and resources and trying to make sure that you get the proper resources you need to really be able to aggressively enforce your mandate. Is there some kind of outside-of-the-box way to work with DCWP to the extent that there are some overlapping cases? What can be done to try to creatively address that?
I think the answer has to be yes. And I think we have in the space, say, of domestic workers, where we both have jurisdiction, our law was amended to give domestic workers, even if they're an employee, an employment space the size of one, the same discrimination protections as others. DCWP also has domestic worker protections, so we have internally created pathways to refer those cases and identify if we are dealing with someone in a domestic worker setting and it's discrimination, is there also a wage and hour violation? Right. Is there also something that is within DCWP's realm? So that's on the enforcement side, which I think our enforcement folks could speak to more. I think on the outreach side, it is in being in spaces together, and for sure around domestic workers, that's another area where I personally would be at events with the DCWP deputy commissioners to talk about changes in the law and what those mean to wide ranges of domestic workers and other advocates. So I think that's a very useful model. And I think we're open to any and all suggestions and to continuing this
Chair
conversation.
Williams agrees, it would be great to do a convening with the two agencies and us and our committees and try to think outside of the box about ways, given the limited resources that you have, of the agencies to further collaborate both on outreach and on case disposition to see how to be, because I know that oftentimes there are silos, and I'm not saying you two are siloed, but ways to kind of break down those silos and see how we can think outside of the box on that.
Well, one thing I wanted to, just to piggyback on what you're mentioning on domestic workers, I think it's a great example. Recently, we announced this past year a domestic worker mediation program in collaboration with the Office of Administrative Trials and Hearings. And that is really, I think, a creative approach to some of the issues that are affecting domestic workers, in the sense that we can bring a worker and an employer into a room and figure out how to mediate a range of issues that we perhaps don't even have, that traditionally we might not have authority over, for example, wage and hour, but we do have authority to over paid safe and sick leave, for example. And the mediation gives an opportunity to address all issues in that situation. So I think that's a great example that the Deputy Commissioner brought up.
Okay, terrific. Well, then we will definitely do that convening. Okay, those are the extent of my questions. I'll turn it over back to Chair Williams.
Yeah, I just had a follow up based off of the questions that Councilmember Menon mentioned, which if you get about 12,000 inquiries a year, 300 to 500 complaints actually get filed. And I know you said some of those cases might have jurisdictional issues. So I guess the question is, do you know what percentage of like the 12,000 you deem like ineligible to sort of have any enforcement power by way of CCHR? Just trying to see percentage wise, like, because 12,000 to 300 to 500 is very low. So would love to like understand how many of those cases are technically not eligible.
Yeah, I think I'll have to get back to you with that information and really dig in, because I think it's also different for different protected categories. And as I was saying, like for disability and gender, a lot of them might be rooted to pre-complaint intervention, and that's why they never become filed cases. But in other areas, it's going to be a little bit different. So I'd like to get back to you with more detail on that.
Mm-hmm. And then I guess a follow-up to that follow-up is the pre-complaint intervention is essentially like when you settle or have some type of resolution without having to like take any further serious legal action, correct?
Yeah, so it's where we don't go through. Typically, if someone comes to us and they have a viable claim, they work with a CCHR attorney to fashion a legal complaint, just like you would see in court, that's filed with our agency, and that's the basis for the investigation and further discussions, hopefully settlement, but sometimes going to oath. In the pre-complaint intervention space, someone comes to us, it is off the bat, we can tell it's a time-sensitive issue that because maybe they have already a relationship with the respondent, we might be able to track down the respondent and get something done. So that means there's no formal complaint is ever filed. So it does away with a lot of the legal process and seeks to resolve a claim just with an agreement for the respondent to either change a policy, give a person accommodation, or something of that nature.
And that gets filed as, those cases get filed as pre-complaint intervention. And so it would be helpful to know like what percentage also of like the 12,000 is like ineligible or pre-complaint intervention. So I think that the narrative, as you know, is that you have all of these cases and you struggle to close the cases because of staffing issues. So just wanted to like understand what that really looks like in detailed fashion. Like how many of these cases are you actually unable to close or truly file because of a staffing issue versus what cases are simply handled without a formal complaint, what cases are technically ineligible, so you can't even take any real action on them.
Yeah, and this is all in like our MMR. I just want to be able to give like life to the narrative of the numbers, and I think the way to do that justice is to talk through specific protected categories.
Thank you. Do any of my colleagues have any other questions? All right, great. Thank you so much for being here today.
Thank you very much.
Thank you.
Thank you.
Okay, now we'll turn it back over to committee counsel to see if there is any public testimony.
Thank you. Thank you to the administration. Thank you, chairs. We will now turn to public testimony. I would like to remind everybody that we will be calling individuals one by one. I have not received any slips for anyone in the room. Is there anyone on Zoom? I'm not seeing. All right. I believe that closes the public testimony portion.
Oh, well, with that, thank you all for joining, and I look forward to continuing this very important discussion.